Hello, everyone. Welcome to today's program, Top 10 Tips for Drafting Enforceable Employment Arbitration Agreements. I'm Ala Policastro. I am the Director of Education and Professional Development at Beverly Hills Bar Association. And today I am delighted to introduce our speakers, Tyler Paetkau and Kathy Huynh. Tyler has been representing employers in labor and employment law matters for 36 years. As both a trusted advisor and litigator, he has handled a variety of labor and employment challenges, including claims of wrongful termination, discrimination, retaliation, sexual harassment, defamation, wage and hour violations, unpaid commissions, collective and class actions, and unfair labor practice charges. Tyler also represents employers in litigation involving unfair competition, misappropriation of trade secrets, restrictive covenants, and employee mobility issues. He also has extensive experience representing employers in traditional union management labor relation matters, including union organizing campaigns, strikes, and collective bargaining negotiations. Kathy represents employers in all aspects of labor and employment law in U.S. and federal and state courts, before administrative agencies, and in arbitration. Kathy has experience in wage and hour, class, and PAGA representative actions, as well as collective actions under the Fair Labor Standards Act. She also litigates claims involving workplace discrimination, harassment, retaliation, failure to provide reasonable accommodations, and other causes of action arising under state and federal laws. She also represents clients in background checks litigation under the Fair Credit Reporting Act. Kathy's clients span all industries with emphasis on technology, manufacturing, and transportation companies. In addition to her litigation practice, Kathy advises clients on California's complex employment laws. She regularly helps employers review and revise their employment policies and procedures, including policies on wage and hour issues, employee background checks, and paid sick leave. Kathy also provides employment law compliance training to management and executives. We can't wait to hear what both of these amazing speakers have to share with us today, so I'm going to turn it over to them.
Thank you very much, Ala, and thank you, BHBA. Sorry for my voice. First of all, I was at spring training this weekend, and my voice hasn't recovered yet. So we're very happy to be here. Happy St. Patty's Day to everyone. I'm going to ask my colleague Kathy to carry me a little bit here, just with my voice going, but I'll try to speak up a little bit. So. You can go to the next slide. We have a relatively ambitious agenda here today, and we welcome questions at any time or at the end. I think there's a chat feature where you can put those questions in. So just to be clear, this discussion today is not about the pros and cons of arbitration, and that's really a separate webinar. I think we could probably spend 2 hours on that, but just briefly, and you all, probably know this, but just to be clear, arbitration does have its downsides. You have limited appeal rights, number one. The arbitration result is generally final and binding. You can appeal it to the Court of Appeal or the trial court even to vacate it, but the grounds, again, are limited. It also has limited discovery in arbitration. You generally are not entitled to a dispositive motion, an MSJ. So there are some downside risks. In addition, if an arbitrator makes an error of law, that surprisingly is not enough to overturn an arbitration award. It's the idea is the parties have entered in and negotiated an alternative method to resolve disputes, and with that, they're giving up some rights. So I will leave it at that for now, but I will just say that arbitration is rough justice, and be careful what you wish for. I think for larger employers with a class action waiver, there's reasons for arbitration, but again, it's not a be all end all. It's not that you have to go to arbitration. Today, we're going to focus on once your client or you as an employer decide, yes, we want to go to arbitration. We prefer an arbitrator. We prefer taking our chances with an arbitrator versus a jury. So we're focusing today on enforceable drafting tips. And, the law over the years um, has supported arbitration. Both federal and California law are supposedly pro-arbitration. Uh, but some of this, the changes in the law, especially, I blame it on the courts. And since we're here for St. Patty's Day, I call it shenanigans by the courts. We have a tug of war between the federal courts, including the Ninth Circuit and the Supreme Court, U.S. Supreme Court, and the California courts, Courts of Appeal, and the California Supreme Court. And you've heard these cases before. Armendariz, California Supreme Court, which announced like minimum standards of fairness for statutory claims. And then since then, we've had a Discover Bank case, which was overruled by the Supreme Court in Concepcion. And most recently, we had the Viking Rivers case, Viking River Cruises, also a SCOTUS case, which embraced the Federal Arbitration Act and found that it preempted contrary state laws. So we're going to not get into the law so much on the what's left after Concepcion and Viking River. That's also probably another seminar, but focus on doing it right. If you're going to do an arbitration agreement, how can you do it right? What are the best odds that it'll be enforced? And just to share a little war story, we all love war stories. The genesis of this program in our article, which is included in the materials, is Kathy and I and a lot of our colleagues often got embroiled in what I call satellite litigation over whether the agreement is even enforceable in the first place. And I had a case a long time ago. It was actually 2014 case called Tiri, Tiri versus Lucky Chances. Lucky Chances, well, the citation for that is 226 Calap 4th 231. It's a 2014 First District Court of Appeal opinion. And in that case, the plaintiff who was disabled filed a wrongful termination, disability discrimination, failure to accommodate claim. Pretty standard stuff in California. I believe she filed her lawsuit in 2012, and the trial court, it was San Mateo, denied our motion to compel arbitration, even though we were correct. Some, especially state court judges, don't like arbitration, and you're already fighting an uphill fight in front of some judges in terms of enforcing arbitration agreements. So in the Thierry case, the trial judge found that we didn't attach the arbitration rules to our agreement. There were some other elements of arguable unconscionability, which we'll talk about sometime a little bit later here. So we took an appeal. The Court of Appeal reversed the decision, and it was really based on the delegation provision, which is tip number one: have an express delegation to the arbitrator provision, because that entire order got reversed. The problem is when we went back to arbitration, I think in 2016, so some 4 years after the plaintiff filed her lawsuit, we went to the hearing and she couldn't speak, absolutely could not say a word. So again, be careful what you wish for, because I guess we won the battle, but we still had to deal with the war, the end of the case. And the purpose of this is to avoid all of that satellite litigation, or at least to make it less likely that you're going to have the satellite litigation. On the prior slide, I just indicated some of these tips are common sense. It's based on fairness, and some of the tips that you see it there, common sense and fairness. There are a few traps for the unwary employer. We'll point those out. Those are not so obvious, but if you don't get it right, it can doom your arbitration agreement from the outset. And we do have a template California arbitration agreement. Kathy and I are still debating what to include in that. We don't like and don't recommend boilerplate for any employment agreements. So it's with some trepidation and reservation that we're going to send you our template, but it does have all the bells and whistles, some options for employers. But just bear in mind, and we'll include a disclaimer, the law in this area, it seems to change almost weekly. We'll get a new decision at a federal court or state court, court of appeal. And then, in some cases, we have to go back to the drawing board or we have to update the employment agreement. So that's a large disclaimer. Lawyers like disclaimers. It's not a one size fits all. And regardless of whether you use our template or not, you should still run it by your local employment counsel, just because of the pace to which these changes occur. Um, the other thing about just drafting agreements, a lot of it is risk tolerance. There are some provisions that if you're going to be really conservative, you just delete them. We're not going to take a chance. There are other provisions. I'm thinking about the employer wants injunctive relief. A court might say that's not mutual. That's a claim the employer is more likely to make for a TRO or injunctive relief, trade secret dispute, for example, but not an employee. So it's about risk tolerance and how much risk your client wants to take in fashioning the arbitration agreement. So next slide. So without further ado, these are our top 10 list, our top 10 tips. So, and just to explain what I mean, the use of a clear and unmistakable delegation clause, that I classify as a trap. You have to use magic language for it. So I call it a trap. Use a standalone agreement with a verifiable signature. In other words, don't bury it in an employee handbook. That I classify as obvious common sense. Number 3, make it clear and understandable. Use plain English. That is obvious and based on fairness. Number 3, make it clear and understandable. Another obvious tip. Arbitrator neutrality, that should be obvious as well. Number 5, I classify as a trap. Because you can select the arbitration rules. You can even select provider rules, like we'll talk about AAA, American Arbitration Association, and JAMS, the most commonly used. But you can fashion your own, and if you do that, you just have to make sure you get it right. So it's kind of a trap, a hidden trap. 6, I classify as a trap. It's kind of a reverse trap. The tip is by including an opt-out period. So the employee is presented with a mandatory arbitration agreement. They have 30 days to opt out of the arbitration program. And we all know most employees will not opt out. They may ask some questions, but giving that opt-out period eliminates one element of unconscionability, which Kathy's going to talk about. That's procedural unconscionability. Most employment arbitration agreements that I've seen still do not have number 6. So that's a big one for today. Number 7, I classify as obvious. You can't tilt the playing field. So this is really, we're having a trial like we would in court. It's just an alternative forum. So you can't shorten statute of limitations, limit remedies, impose undue cost on an employee. All of those factors, tilting the playing field will affect and potentially invalidate your arbitration agreement. Number 8, I classify as another trap. Enforceable waivers. I know we're going to talk a little bit about the Private Attorney General Act, everybody's bane. It's been reformed, I heard, in 2024, but the reforms didn't take. I haven't seen any reforms yet. So we're still dealing with PAGA claims and whether the individual claim can be compelled to arbitration under one of these agreements, even if the representative claim stays in court. Number 9 is another obvious tip, and that is, as we said, the law changes constantly. So it's common sense to keep your agreement current, review it periodically, maybe even calendar reminders, every couple of months to make sure there's nothing new that requires an update to your agreement. And 10 is obvious, but it's worth saying, and that's implement sensible protocols and regular employee training. In employment law, having done it for 36 years, but who's counting, employee training is really, really important. It's often not emphasized enough how important that is. That's everything from what is our program? How is it explained to the employees? Um, what disclosures are made to the employees? You may have an employment agreement that's presented, but then a separate policy around the arbitration program that it could even include FAQs for the employees. So those are all important protocols and training managers in HR when they get questions about the arbitration agreement, at least have them send them to a designated person who understands the arbitration program and can answer questions. So by my count, 6 out of the 10 tips that we have here are obvious. So they're already in your minds. They're common sense. So we are going to go over them just to, not to beat a dead horse, but just make sure they're in your minds going forward. And a lot of this is for HR and compliance. So next slide. So I thought I would start. This is the most recent California Supreme Court decision on arbitration, Ramirez versus Charter Communications, decided in July of 2024. And this is a good illustration of drafting errors, how drafting errors can doom an arbitration agreement. In this case, it obviously went up to the Court of Appeal, then to the Supreme Court. Supreme Court found that several provisions in the employer's arbitration agreement were unconscionable. And, it's the obvious things that are frequently targets. The agreement unfairly limited discovery. It shortened the statute of limitations for certain claims. Remember, especially for statutory claims, wage hour, discrimination, harassment, retaliation, those are now subject to longer statute of limitations. Excuse me, for wage hour claims, you're looking generally at 3 years liability created by statute, or 4 years if there's a companion unfair competition claim under Business and Professions Code, Section 17200. Lacking mutuality. I use the example, hey, this has an exception. The employer can go to court for injunctive relief, or maybe the agreement says both parties can go to court for injunctive relief. But the courts have said, wait a minute, that's not something that an employee is going to go to court for. That's an employer benefit. And as a result, the agreement lacks mutuality. So in the most recent case, Ramirez, the Supreme Court remanded the case back to the trial court to make these findings and decide whether to sever some of these unconscionable provisions and enforce the remainder of the agreement. And Justice Corrigan wrote for the court. You can see the quotation here. And I wish there was more guidance than this, but you have to look at the, quote, totality of the circumstances. And importantly, a court can't just rely on 1 or 2 provisions and say, okay, I'm throwing it out. It's unconscionable. It's not enforceable. But I would submit you don't want to be in that position where you're defending multiple provisions in your arbitration agreement, as opposed to one maybe that can be severed. The one thing I might add, based on the Charter Communications case, is a tip 11, which is also obvious, but to include a severance agreement in your arbitration agreement, allowing an arbitrator or a court to sever any unconscionable provisions. Any provisions that go too far can be severed, and the rest of the arbitration agreement can be enforced in court. The case also points out the primary challenge do we get to arbitration agreements even today is unconscionability. And there's a procedural unconscionability, which we'll talk about, and substantive unconscionability. You have to have both to have an unenforceable agreement, although they don't have to be present in equal measure in the agreement. So with that, I think we'll go on to the first tip. So delegation clause, what is it? So if you read, you go back and you look at the Thierry versus Lucky Chances case. Fortunately, we had a really good delegation clause in that case, and the Court of Appeal relied on that in reversing the trial court finding and said the delegation provision itself was not unconscionable. It didn't have any elements of unfairness. And the typical delegation clause says that all disputes, claims, or controversies arising out of or relating to this agreement, including the interpretation, validity, enforceability, or scope of this agreement, or any part thereof, including whether a particular claim is subject to arbitration, and any claim that all or part of this agreement is void or voidable, shall be determined exclusively by a single neutral arbitrator, and importantly, not by a court, not by a court. So you need to include that in every arbitration agreement. It's rule number one. A recent example is the Jack versus Ring case we have cited here, where the court found it was ambiguous. It wasn't clear and unmistakable because one provision delegated to the arbitrator the validity of the agreement, while another provision suggested a court could find the contract unenforceable. So it's kind of a mixed message there. So it has to be clear, it has to be unmistakable. And I mean, Thierry is a good example. There's other cases. Some of them are cited in our article. I know one was called Malone, which has examples of clear and unmistakable delegation clauses. And then you get a result like we got in Thierry, where the Court of Appeal said, we have no jurisdiction. We can't even weigh in on unconscionability of the remainder of the arbitration agreement because of the delegation clause. It goes to the arbitrator. And by the way, you can use the JAMS or AAA rules. They have sample delegation clauses that have been blessed by the courts. So that's another source if you want to look at a sample delegation clause. If you read Thierry, it's in page 1 of the agreement that has the delegation clause. So this, is pretty obvious too, using plain language, specifically referencing the arbitration agreement. Again, this is in a standalone agreement, not in a handbook or a larger employment contract. Sometimes we see the employment agreement included in a proprietary information and invention assignment agreement or a larger employment agreement. And that's okay, not preferable, not ideal. It's better to have a standalone agreement for sure. Next, I'll turn it over to Kathy.
Good afternoon. So I'm going to cover a few of the drafting tips that come up when these agreements are actually challenged in litigation, especially issues around electronic signatures and how the agreement is presented to employees. As Tyler mentioned, use a standalone agreement with a verifiable signature. And one of the biggest enforcement problems that we see in arbitration cases is proof that the employee actually agreed to arbitrate. Courts have rejected arbitration agreements when the employer cannot clearly show like assent. Courts have emphasized that arbitration provisions should not be buried in employee handbooks or acknowledgement forms, as Tyler mentioned. And one of those examples is in the Mendoza case where the Court of Appeal refused to enforce an arbitration clause that was embedded in a handbook and was only supported by a generic handbook acknowledgement. In practice today, that often means electronic signatures, which are perfectly valid, but only if the employer can prove who actually signed it. In a case that I litigated a couple years ago in Montez versus Motel 6, venued in Santa Barbara Superior Court, the plaintiff in that case, he claimed that he never agreed to arbitration. but the court granted our motion to compel because we were able to show exactly how the employee electronically accepted the agreement through Workday. And in that case, I think what made the difference was the audit trail and the security features of the system that we were able to produce to the court. As part of our production, the evidence showed that the employee, he accessed Workday using a unique username and password. And then the arbitration agreement appeared in the employee's Workday inbox as an action item that he needed to complete. We also showed that the employee could open the agreement and review the full PDF. And as he was doing this, the system recorded timestamps, session ID, and login credentials. And the agreement could also only be accepted while he was logged in using his specific employee account. So this kind of evidence satisfies the authentication requirements discussed in cases like Espejo versus Southern California Permanente Group. The court looked for, in that case, the court looked for proof that the electronic signature was actually the act of the employee. So I think from a practical standpoint, there are several implementation steps that could strengthen enforceability when we're dealing with electronic signatures. And nowadays with technology, most of these arbitration agreements are presented to employees through some kind of electronic platform like Workday.
Just on that third bullet point there, Kathy, this is common, employers like flexibility, right? So we see these all the time in handbooks, in policies. This is informational, not contractual. The employer can change it any time, and they are sole and absolute discretion. It does not create a contract of employment. All of that runs counter to getting an agreement to arbitrate. It's inconsistent with a contract.
Thanks, Tyler. So just some tips. I think if the arbitration agreement is delivered through an electronic platform such as Workday or another like HR system, best practices, present the agreement in like a separate window or pop-up and display the full agreement, not just like a hyperlink. Provide the agreement in English and the employee's primary language, such as Spanish. I think we will discuss that a little bit further during this presentation. One of the key things that really helped us be able to enforce the arbitration agreement in the case I litigated was require the employee to affirmatively type their name as an electronic signature rather than simply clicking I agree. I know a lot of pop-up windows, we have a little box that they could just check, but here in our case, the employee actually had to type out his full name. Also, I think one of the important things to do is include language right above the signature line, confirming that the employee understands that they are signing a binding arbitration agreement. So that language disclaimer right above the signature line helps. Provide a print or download option where the employee can download or print out the entire agreement. And afterwards, even after signing, ensure that employees can access their signed copy later in whatever HR platform the employer is using. So I think these tips demonstrate that, there's clear assent on the employee's part that they are assenting to an arbitration agreement. It also, by doing these steps, I think it creates an evidentiary record that you can use later if the agreement is being challenged in court. Because the reality is that, these arbitration agreements are often tested years later in litigation. So if you can't reconstruct the signing process, I think enforcement just becomes much harder. Next slide, please. So arbitration agreements should be written in understandable language. Another recurring problem that we see is clarity and accessibility. So when California courts examine arbitration agreements, they look closely for procedural unconscionability, which focuses on whether employee had a meaningful opportunity to understand what they're signing. So the agreement should be written in plain language. We would avoid dense legal jargon, excessive cross-references, or provisions that obscure the key point. And the key point being that the employee is agreeing to resolve certain disputes through arbitration instead of court. As I mentioned, language accessibility is critical. There's cases you'll see here where the court found procedural unconscionability, where the arbitration agreement was presented only, for instance, in English to employees with limited English proficiency. And even in the Ramos versus Westlake Services case, the Spanish version of an employment agreement actually omitted the arbitration provision. So even though it was translated in Spanish, certain parts of it were omitted, and the court treated that as fraud in the execution. In the Juarez case, also inaccurate translation, the court found undermined enforcement. So the key here is that translation must be accurate and consistent. And I think if an employer provides the agreement in Spanish, for example, the Spanish version must contain the same exact arbitration provision as the English version. And from a practical standpoint, this also ties back to like the electronic presentation of agreements. I think if the agreement is provided electronically, the employer should consider, displaying both the English and Spanish versions and having a function that allows the employees to kind of toggle between the languages, because some may have limited proficiency, but they may have limited, English language skills that where they can make the comparison. Well, are the English and Spanish versions identical? And just, like ensuring that the agreement is formatted clearly with headings and readable fonts. These steps, help demonstrate that the employer is making a genuine effort to ensure that the employees, understood the agreement that they were signing. And, that reduces the risk of a court later finding that there was procedural unfairness. I'll pass it back to Tyler for the next slide.
Thanks, Kathy. So this is another obvious one in ensuring arbitrator neutrality. So in the old days, a lot of companies, I shouldn't say a lot, but some would have a designated arbitrator or somebody that's not necessarily on the company's payroll, but a constant referral for arbitration. That's problematic under the law. That's Armendariz. At a minimum, the arbitrator should be neutral, and the employee should have some meaningful participation in the selection process. Even if you get a slate of proposed arbitrators from JAMS or AAA, and I know you working with them, they'll send you a list of 10. You can rank them, and then there's an ability to strike certain arbitrators, but it has to be mutual. So the employer and the employee have equal say in the selection of the arbitrator. Even with employee participation, we still get arguments, although not as much as in the old days, the repeat player effect. Hey, this arbitrator is not going to be fair to the employee because they're being retained by the company many times over. So the repeat player effect naturally leads to bias against the employee. So JAMS and AAA, the other providers, I know there's a lot more recent signature resolution, ADR services. I'm sure I'm missing a few. Judicate West is another one. They're striving for fairness as well in the process. They don't want, their name in a court opinion saying their process was not fair. Excuse me, the arbitrator selection process was not fair. So just on this arbitration selection, the safest, the easiest way is to incorporate the JAMS or AAA or another provider's selection process so that it kind of removes it from the employer, and you have the neutral that's administering the process and making sure that it's fair and there's adequate participation by both sides. the way it works, if those of you who've done arbitrations know this, but you can indicate to JAMS or AAA when an arbitration is filed the expertise that you'd like to see in an arbitrator. There's no guarantees, and you probably get many, many different opinions on the quality of the arbitrators at the different providers. I've used both AAA and JAMS. JAMS tends to be a little more expensive, just to be honest, and the arbitrators slightly better quality. If you ask for an employment lawyer, you generally get them on your list. AAA, you might get them on your list, but they might be in New Jersey or Florida, as opposed to California. So just a word to the wise about selection of which arbitration provider to use. Next slide. So this is another tip to specify the applicable law and the procedural rules. That is as we say here, a recurring source of litigation. And you can elect to have the Federal Arbitration Act apply. If for some reason it doesn't apply, there's no interstate commerce, the California Arbitration Act can apply. There are some differences between the two. Most notably, I just discovered this week, the California version allows the parties to expand the standard of review, and the cases so far under the Federal Arbitration Act don't allow that flexibility. It's the same old, it's got to be manifest injustice, corruption, fraud, and the failure to disclose by the arbitrator. It's a very, very high bar. And again, conversely, under the CAA, you can even select an appeal within arbitration. And JAMS, it's not used frequently. I'm not sure why, but they have a Rule J in JAMS. It's called appeals. And it essentially provides for a right of appeal from an arbitration award. They would go to a 3-judge panel or 3-arbitrator panel, and they would sit as a court of appeal over the arbitrator's decision. So it's still an arbitration, but you have the same rights you would have if you were to appeal from a bench trial judgment in a superior court. So it's something that's different under California law. The other thing I would note here is that, as especially the employment lawyers who are on the meeting, California in 2017 passed a law, California Labor Code Section 925, and that allows an employee to void a non-California venue or choice of law, even in an arbitration agreement. If the employee goes to court, they can get an injunction, declaratory relief that's void, and they get their attorney's fees. So there's a risk in including non-California venue, non-California law in your arbitration agreements. So just a word to the wise there. Labor Code Section 925, it applies to contracts signed on or after January 1, 2017. So for a while there, we had an excuse. Hey, it was signed before 2017. That's, what is that? 8 years later now, so you can't really rely on that anymore. New contracts, you can't have, New York law or distant venue for the arbitration. That 925, by the way, it applies in both litigation and arbitration. So employment contracts can be voided with non-California choice of law or venue for an employee who primarily lives and works in California. That's the standard. Next one. So as I mentioned, the arbitration can specify which law should apply or both. The CAA could be a fallback if for any reason the FAA doesn't apply. If instead you want an appeal right, you're going to want to go with the CAA, which allows for a modified standard of review by a 3-arbitrator panel within JAMS. It's JAMS Rule J in JAMS. And I'll just read a portion of it. This was actually just revised February 1, 2025. It's called the JAMS Optional Appeal Procedures. I think a lot of employers don't think of it because they think it might apply to construction arbitration or commercial arbitration, but it's not limited. And subdivision J says the appellate panel, again, the three arbitrator panel, will apply the same standard of review that the first level appellate court in the jurisdiction would apply to an appeal from the trial court decision. So, in other words, it's just like you had a bench trial and you get a full relief in the Court of Appeal. It doesn't make it more likely you're going to win your appeal. You just have more to argue about, more things to bring up with a broader standard of review. And again, you want to identify the procedural rules. Hindsight is 2020. I didn't draft the Thierry Lucky Chances arbitration agreement, but knowing now, knowing now what I know, I would have attached the rules, not just they included a website to JAMS, and it's better to just attach the rules to the arbitration agreement. We use the website because even JAMS and AAA are always updating the rules. So what you attach in 2026 might not apply in 2030. But I would do belt and suspenders. Here's the current version attached as Exhibit 1, and here's the website to the JAMS rules or AAA, Judicate West, Signature Resolution, ADR Services. I'm sure I'm missing a few. And the last bullet point there is if you learn nothing from this program, you will learn bespoke, selected by the parties. It comes from the 17th century and Seville Row, where a customer bespoke or spoke for a specific bolt of fabric. So that's what it is. The parties select the rules. Those can be negotiated. I mean, Kathy and I are negotiating right now on one, and you have flexibility. It's a matter of contract and consent. So those can be tailored to the parties within reason. Back to Kathy.
So one of the most common defenses to enforcing arbitration agreements is unconscionability, which we previously touched on a little bit. In California, unconscionability has two components. There's procedural unconscionability, which looks at oppression or surprise in how the agreement was actually presented to an employee. Then there's the substantive unconscionability, which looks at whether the terms are overly one-sided. Even when you have terms that are fair, though, courts can still find procedural problems if the employee was not given a meaningful opportunity to review the agreement. For example, in the Carlson versus Home Team Pest Defense case, the court found that there was procedural unconscionability where the agreement was presented as a non-negotiable take it or leave it, and the applicant risks losing unemployment benefits if she refused to sign. So it's really important to provide time to review the agreement, and that helps address that concern. I think best practice is providing the agreement before the employee must sign it, and allowing employees to review it outside of the onboarding session. A lot of times with new hires, they come in for like a 1-hour session to meet with HR, and they're signing a lot of paperwork, and the arbitration agreement is just embedded in that stack of paperwork that they're asked to sign. So giving the employees an opportunity to review the arbitration agreement and signing it on its own helps address that concern. And also encouraging these employees to ask questions or seek legal advice. I think that's really important. In the Montez case that I litigated that I mentioned, the court actually looked at how many days the employee had to review the arbitration agreement before accepting it. And because of the audit trails that we produced, it showed that the employee actually had 19 days to review the arbitration agreement before he actually signed the acceptance on Workday. And then the audit trail also showed that he went in and opened the pop-up windows multiple times throughout this 19-day period prior to signing it. So I think that was really helpful for supporting enforceability in our case. Also in that case, the system allowed like I mentioned, the employee to actually print out a copy of the agreement and take it home with him if he needed to. And specifically for this case, there was a contact person, an HR person that the employee could reach out to with a phone number if the employee wanted to discuss the agreement or had any questions. So these kind of procedures help demonstrate that the employer did not rush or like pressure the employee into signing, and that the employee had like a real meaningful opportunity to review and understand the agreement that they were signing. Next slide, please.
Just one point quickly on the so courts call this a contract of adhesion. That's really the procedural unconscionability argument. And I mentioned the most recent California Supreme Court case from July of 2025. There's actually another case this year, February 2026, a case called Fuentes versus Empire Nissan. Fuentes versus Empire Nissan. And in that case, the font, the print in the arbitration agreement, the court said with the typeface in the agreement was not only strikingly minute, but also blurry, rendering it unreadable. And the trial court said it was unenforceable. It was both procedurally and substantively unconscionable. The Court of Appeal reversed the trial court and said that Fuentes, the plaintiff, had failed to show both procedural and substantive. The illegible font the court said that went to procedural but not substantive. And on appeal to the Supreme Court, the court found that the tiny and unreadable print is a problem of procedural unconscionability, and it should not be double counted as substantive unconscionability, but emphasize the unfair bargaining power between the parties. And courts in this, we see this a lot in arbitration decisions, very paternalistic, very protective of employees, and any attempt by employers to force something or coerce them, shorten the time to review it. It's a condition of employment. So courts are going to be skeptical. And small print, the court in Fuentes also remanded the case. But I would say when they can't read the agreement, it's dead on arrival. You're going to lose. So that's the one case to look at as well. Fuentes versus Empire Nissan, February 19, 2026.
So going back to what Tyler briefly touched on was the opt-out provision. I think that's another feature that can significantly strengthen enforceability with arbitration agreements, because an opt-out clause, allows the employee to decline arbitration within a specified period, like for example, I think 30 days after receiving the agreement. That's pretty common. And courts favorably, view opt-out provisions because they undermine arguments that, the agreement was purely a take it or leave it agreement for the employee. And if employees truly do have the option to opt out without retaliation, I think the agreement just appears less oppressive and less procedurally unconscionable. But to have the opt-out option, it must be genuine. I think employers should have that, it has to be clearly explained that there is an opt-out provision and that the process is simple to use and employees are not discouraged or pressured from opting out. And one of the most important things I think is documenting this process. Having documentation to show that there was an opt-out provision, if it was, taken by the employee, and make it simple, like, make it that the employee, if they want to opt out, they can just send an email or submit a form through HR or just mail some type of written notice. Because the key point we really want to show is that the employee has, real choice. And when courts see that the employee had the ability to opt out, and then, many employees chose not to, I think it's just much more likely to view the arbitration agreement as fair and, voluntary. Next slide, please. I think I'll pass that next back to Tyler.
Thanks, Kathy. I was just answering a question here. The case that I mentioned earlier is called Fuentes versus Empire Nissan. That's the most recent California Supreme Court decision. But keep those questions coming. I had to find the Q&A bar there. So this is another obvious one. We're deciding the same dispute in a different forum. So these are, really dead on arrival, excessive discovery restrictions. I will say arbitration is designed to be more streamlined. Generally, you get one deposition per side, limited written discovery. But if the arbitrator unnecessarily restricts it, or if the rules don't allow for broad discovery, that could be problematic. Fee shifting is a common one. So the employee, I think, what is it now, Kathy? What are they paying? $480 as a first initial appearance fee in court. So they can't be charged more than that to go to JAMS or AAA or any other provider. They can't be liable for arbitration costs unless it's allowed under the substantive law. And that's something that you want to address in your arbitration agreement as well, whether the arbitrator has the power to award sanctions, for example, or fee shifting if the law allows for it. But another one we still see frequently, not so much from California-based employers, but employers on the East Coast and the Midwest and the South, shortened statute of limitations, not helpful. Limitations on remedies and damages, also, not helpful. That leads to a finding of substantive unconscionability. So again, even if you give them 30 days, talk to a lawyer, take your time, you can opt out, and it's all done correctly. If you have these provisions in there, you'll still get a challenge or could get a challenge to enforceability on substantive unconscionability grounds. Another thing we constantly see is limiting remedies. It's so tempting as an employer to say, okay, we designed this program as an alternative. Let's just tilt the scales a little bit. So you can't get punitive damages. You can't get consequential damages, whatever that means. Not allowed. You're restricting remedies that an employee might get in court. So if the FEHA, Fair Employment and Housing Act, if the wage out orders, the labor code allows for employees to recover their attorney's fees if they win, that's the law. You can't alter that. Nor can you say in an arbitration agreement, we'll just override the labor code and say, if the employer wins, it gets its fees. If it's not allowed under the law, that would be unconscionable, substantively unconscionable. We see those a lot. And it's like the charter case I mentioned at the outset, California Supreme Court, where the court did find several provisions were unconscionable. Next slide. So I'm gonna ask Kathy to weigh in here as well, but there's been a lot of back and forth about class action waivers and class and collective action waivers. We see a lot of PAGA claims, and I would say that currently most trial courts, when you file a motion to compel arbitration of the individual PAGA claim, they will stay the litigation, the representative litigation, because if an arbitrator finds that the plaintiff, the named plaintiff, was not an aggrieved employee, they don't have standing to go back to court and litigate the representative action. So most, but not all trial courts are respecting arbitration and forcing the individual named plaintiff rep to go to arbitration first and stay in the litigation. That's the last bullet point there. And you see the PAGA statute, which is really a problem, I think, for a lot of employers, especially when they use it strategically. What I've seen recently is the plaintiff will say, hey, wait a minute, I'm disclaiming any individual recovery. I only want to bring a representative action. So forget about that arbitration agreement. I'm going straight to court. It seems like a ploy, right? But so far, at least what I saw last night, the California Courts of Appeal are split on whether that's permissible or not. So stay tuned on that front. Whether an employee could eschew the individual action or individual right to relief and just only pursue in the representative capacity in court. Kathy, do you want to say any words about that?
Yeah, so it's true that we've come across most courts respecting arbitration and compelling plaintiff to arbitrate their individual claims. And usually, generally, that is a better route to take, because sometimes in arbitration, we could prove that the plaintiff was not a quote unquote aggrieved employee, and therefore she or he would lack standing to come back into the state court action and be the representative. Some courts, however, have refused to state the state court action pending the arbitration. We've had a couple of those decisions in the last couple of years, but generally, for the most part, I think courts are willing to stay the representative action and pending the arbitration results of the individual's claim.
Next slide. So this is on the tip of enforceable waivers. So if you do want a class action waiver, be clear in your arbitration agreement that you want that. That is allowed under the FAA, the Federal Arbitration Act. It's a matter of consent. So if it's silent, a court will not imply a mass arbitration or a class arbitration. But don't take chances. I would just include your class collective action waiver. You can't waive a PAGA claim. That's the Epic Centers cases since then, because it's brought as the people of the state of California. You're a private attorney general. You're acting on behalf of the state. The state is not a party to the agreement. So the PAGA representative claim, at least, cannot be compelled to arbitration, even after Viking River cruises. But you definitely want to include that if you are going to have an arbitration agreement, the class action waiver. Next one. So the last two, are really obvious things. It's a good reminder. The law changes constantly. They also, as the last bullet point says there, it shows good faith and helps with enforceability. We didn't just send them an agreement, sign it and return it. And by the way, it's still okay to have paper wet signatures. Many years ago, that's all we had. You just have to be more careful about record keeping and making sure you're tracking the signatures. But all of this goes to show the court, hey, we're trying to be fair. We're training the employees. We're providing updates. Hey, we created this FAQ so they could read it on their own. It's not legalese. They could take it to their lawyer, review it. So all of that helps on overall fairness and enforceability. Same thing with the last tip. number 10, and that is training, especially HR. It's some of it is obvious, some of it is not. And the more guidance you can provide to HR, to managers, and also with employees. I know some employers have a robust arbitration agreement or arbitration program, and they will hold 2-3 hour sessions to go over the program, answer questions. There might be a follow-up meeting, additional training sessions. All of that is positive. You can't do enough training. You cannot do enough training. So that's my last of the 10 tips. I see we're at our witching hour, and we left a couple minutes for questions. I was going back to the Q&A here. Let me find it. So I don't see new questions. One question from Alyssa Hearns is, although the opt-out provision is favorable, can employers require arbitration as a condition of employment? The answer is yes, and continued employment can be adequate consideration for the arbitration agreement. But, this is a good question. What happens if the employee says, no, I don't want to agree to arbitration? Then what do you do? Kathy, I'm going to throw that question to you.
You know, I think part of this process of, requiring, I think the Ninth Circuit Court of Appeals tried to rule, they actually held that the FAA, which is pro-arbitration, says that you can require that as a condition of employment. And I think going back to the tips too, is that we basically showed to the court that, it was presented in a fair, conscionable, manner with the, everything was clearly explained to them and that the terms were fair. And I think if we prove all of those steps that we had just, talked about, I think really, is in our favor for the employer to really require the employee to sign the agreement, so long as, it's procedurally and substantively conscionable.
So back to the question, or the hypothetical, purely hypothetical question. If at the end of the 30 days, the employee says, hey, I talked to my lawyer and I'm not willing to sign up for arbitration, if it is a condition of employment, it means you don't want to work here. I mean, that's really the practical effect. We're not, they're not challenging the arbitration agreement in court because they refuse to sign it. But the trade-off is they don't get employment. It is a condition of employment, and that's lawful. That's a lawful condition. The opt-out is just in case it's challenged, you have a defense, and it eliminates well, I don't want to be too categorically, but it takes out of the arsenal the procedural unconscionability argument if you can show they had 30 days to opt out or to ask questions about the agreement. So with that, we're just a little bit, the follow-up question, is the employee deemed to have resigned in that instance? I would do belt and suspenders. I would confirm, based on your failure to sign the agreement, which is a mandatory condition of employment, the company is not willing to employ you. So hopefully by that point, you haven't already made them maybe you've made them a conditional offer. You revoke the offer or rescind the offer. The unwillingness to sign the agreement means that the employment ends. So with that, thank you everybody for staying on. Sorry about my voice. I blame it on spring training. And happy St. Patty's Day. Thanks, Kathy. And send us any questions you might have. And we also are going to, for those who are interested, let us know. We'll send you our template with all the bells and whistles as of today. It's good today only.
This concludes today's presentation. Thank you so much, Tyler and Kathy, for an excellent presentation, and thank you so much to our audience. Have a great day, everybody.